Good afternoon, everyone from Nairobi, Kenya. Despite your time zone, I'll just use the time zone that I'm in. Welcome to this open day. My name is Mercy Okiro. I will be moderating the panel discussion later. And for this session, I'll be presenting to you the slides on CIArb generally and how to join as a student member. Anyone who has questions, kindly type them in the chat box. They will be addressed by me and also subsequently in the panel. For this session, I will take 30 minutes on the slides and then we'll do a Q&A session and then we'll have a short 5-minute break from, let me see the time zone, yes, 12:40 to 12:45 London time. And then after that, we'll do the panel discussion. I'm a young member of the Chartered Institute of Arbitrators Young Members Group. I formerly sat on the steering group of the Young Members Committee. I am a lawyer in Kenya, Nairobi, Kenya. I'm also an accredited mediator of the Chartered Institute of Arbitrators. I've also been trained by the same Chartered Institute of Arbitrators as an arbitrator. And I've done construction adjudication, but I will follow up on the completion of that. I'm also an accredited pathway tutor in mediation and arbitration. I will share my screen shortly so that I can start the presentation. Okay. For those interested to understand about the Chartered Institute of Arbitrators, one second, yes. It is an international center of excellence, of course, for the practice and profession of alternative dispute resolution. And this is generally the entire alternative dispute resolution spectrum. And then CIArb has networks in terms of branches. We have 41, by we, I'm saying we because I'm a member, so I have owned it. So we have 41 branches all over the world. And the Chartered Institute of Arbitrators also provides education and training for arbitrators, mediators, and adjudicators. Also, it has other resources, of course, as you can see, which include guidance, support, advice, networking, promotional opportunities, as well as facilities for hearings, meetings, and other events. CIArb is a non-for-profit UK registered charity. I cannot say everything about CIArb. That is just generally what the overview of the organization. And of course, more information is available on the website. Now, just to look at the figures specifically, in terms of membership, CIArb has over 16,500 members spread over 149 countries. We also have 4,000 members who are now young members in over 100 countries. I will explain later how the distinction is between young members and general members, like I'm also a young member. We also have a global network of like-minded and qualified people, such that when you have a qualification from CIArb in terms of training, this qualification is used worldwide, basically. It's not just that you have to be based in London. Further now, with the introduction of student membership a few years ago, and now that it has been revamped, we have over 800 students now registered. Now, these are basically, this document will be circulated at the end of this webinar to the registered attendees rather, but I'll just go through it. You can see the strategic aims, first of all, to promote the constructive resolution of disputes. Number 2, to be a global inclusive thought leader, which really it is. And then number 3, to develop and support an inclusive global community of diverse dispute resolvers. What I've basically told you, CIArb trains adjudicators, arbitrators, mediators, and it's global it's a global qualification. These are the values of CIArb. You can see ownership and accountability, dignity and respect, professionalism, loyalty, and trust. Now, in terms of, I can say ownership and, in terms of loyalty and trust, I'll tell you, CIArb gives you a sense of belonging. And so that I always say that when you're a member of CIArb, wherever you are and you meet another CIArb member in a different jurisdiction, this is basically one large family. And it's a large family of alternative dispute resolvers. So that now you feel like you belong to a community worldwide. And it's a large community, as you have seen, of over 16,500 members and 8,000 student members. It's 4,000 rather. So of course, treating individuals with respect, valuing and recognizing the importance of diversity and inclusion for all. That is true. CIArb has been at the forefront of pushing for more people from diverse backgrounds to join the dispute resolution space, that is ADR. And I'm one of the beneficiaries of this. Now, this is the history. CIArb is quite old, as you can see, so it comes from a place of rich history. It was founded in 1915 and granted a royal charter in 1979. As it is today, it is the only membership body that oversees the global promotion, facilitation, and development of all forms of private dispute resolution. The Institute celebrated its centenary year in 2015 with flagship events held around the world. The Africa centenary celebrations were in Zambia, I remember, I think, yeah. So as you can see, Zambia or South Africa, but that's besides the point. The point is that the institution has been there for long, so it brings a lot of history and also expertise in terms of being there for long. Now, the CIArb membership types, as you can see, are 5 from this slide. Student membership is ideal for those students, for those studying at a university or other higher educational institution anywhere in the world and have an interest in ADR. So that student membership ideally is free rather. And this is the lower level entry point. Then you move to the next level, which is associate. It is still entry level. And for you to be an associate, to that now you can use the postnominal letters CIArb. It means you either have to complete one of CIArb's introductory courses, that is either introduction in construction adjudication, arbitration, or mediation, or demonstrate to the organization that you have a minimum of 6 months experience in ADR, that is if you seek an exemption. Once you become an associate member, and the pathways to training, which slide I will discuss this more on, is the member. So once you become an associate member, for you to now move to the next level member, which is MCIArb, like I am MCIArb now, you sit further papers, and this now is at the intermediate level in terms of experience and also expertise. Now, you can be a member either through the mediation pathway, the arbitration pathway, or the construction adjudication pathway. The last level, this is the fellow. So those are the people who use FCIArb. This is a person who sat all the levels of exams, either through whichever pathway, as I've said, either in construction adjudication, mediation, or arbitration. So this is considered now the peak professionalism. So that even in terms of appointments, you see fellows are given more complex matters, and even in terms of recognition amongst the community, fellows are deemed to be more experienced. Now, a chartered arbitrator is the last level. A chartered arbitrator, as you can see from the other levels, associate member to fellow, you have to sit for exams or assessments as it were. The chartered arbitrator now, this is a recognition of a fellow who has demonstrated to an interview panel, which is usually more like a peer review panel, who shows advanced knowledge and understanding of arbitration in its practical application. And also you also have to demonstrate things like your contribution to the field of arbitration. So that maybe you write articles or you teach, you've done a number of arbitrations, complex or not, and you have acquired knowledge practically. So this is not an exam level. This one, it's a recognition by the Chartered Institute of Arbitrators. Now, student membership, to learn more about it, it's free. And it's open to anyone studying at a university or other higher educational institution who is not otherwise qualified to join CIArb at any other membership grade. Because when it comes to CIArb courses, there are some prerequisite requirements for you to sit for the courses, maybe like an undergraduate degree, at least in an area. So a student who also is interested in ADR can join in the meantime before they can now look at the qualification in terms of now pursuing professional qualifications under the training pathways. Being a student member also gives you, as you can see, access to a range of benefits so that you can take your courses, but now since you're a student member, you take them at discounts. And also you'll have access to the e-resolver, the CIArb publications. You'll have access to the CIArb website, so that you'll also see other things that even fellows see. So you won't just be a student member with no benefits. As you can see, for more information, I'll share this link. At the end of the presentation, the link will be shared. And also, of course, these slides will be shared so that you see more information and also how to register as a student member. These are the benefits. There are e-learning courses, of course, which I will talk about in a short time. Courtesy of the pandemic, CIArb courses have gone online. And so even those who could not afford to move to a country, because CIArb does not have branches all over the world. It's all over the world, but 41 countries have now actual physical branches. So that now when the courses have gone e-learning, it's easier because now students you can access from anywhere in the world. We also have competitions. For instance, there's the Young Members Group competition, the ESE competition that is usually held annually. You can access that. You also have an opportunity to have your work published on the website. That is, if you have let's say an article that you've written or a commentary on a recent development in ADR, either in your country or elsewhere, it can still be published as a student member. And also, courtesy of, as I said, CIArb is a one happy family. You also get access to experienced practitioners who speak at our lectures and also attend events. So you can go and seek mentorship, and you can also connect with them later, even for job opportunities. A lot of possibilities are open. Of course, there's networking, both with the student members and also other members of the CIArb family. There's also an opportunity, of course, to meet other people through the YMG, which is the Young Members Group. And you also keep up to date with the latest industry news. There's the magazine, the Resolver, and then there's the e-Solver newsletter rather. The e-Solver is usually brief in terms of the information. The Resolver is a magazine, so it's a bit more comprehensive. Then finally, there's a peer-reviewed journal of international arbitration, mediation, and dispute management. It's actually, I'll say, when I say peer-reviewed, it really is. It's one of the best resources in terms of quality and also articles in the arbitration and generally dispute resolution space. So you also get access to this. Now we have the Young Members Group, which now I'm a member of because I'm not a student member. It's open to all members aged 40 and under. Members have, the Young Members Group organizes their own events. We hold an annual conference. We have training days, workshops, competitions, and also similar opportunities to have work of the young members promoted online. So the Young Members Group right now, not right now, it always has a global steering committee, which is a group of young members who volunteer their time to do day-to-day planning in terms of activities to target younger members globally. The current chairperson now is Laura West, and the vice chairperson is Sebastiano Nessi. I was a member of the Global Steering Committee until last year, which was a really good experience for me in terms of networking, learning, meeting people. I've made friends for life. So yeah, it's a good venture. Now, as I explained, the qualifications and postnominals, that is CIArb, MCIArb, and FCIArb. As I said, they are recognized globally in the ADR committee. The CIArb qualification, honestly, in arbitration and mediation and generally ADR, in my opinion, has come to gain worldwide recognition and acceptance in the ADR field, no matter where you are, because the courses are top-notch, and courtesy of being there for long, it has gained acceptance even in terms of quality. Membership training courses are for people who have no experience in ADR, and membership assessment courses are for those who already have experience and can be assessed and qualified. Now, the difference is that by membership training, it means you attend based on how the module is structured. You attend the course and either virtually, now, of course, virtually, where you'll go through some tutorials and then you sit exams. But if you're confident in your skills and you say you've been acting as counsel, but you've never really done a training course, then now you can seek to be exempt from the tutorials and then you just go straight to the assessment. But then this is encouraged for those who already have experience in ADR. So that's now based on the level that you are, you can go straight to MCIArb or whichever level that you will be seen to be. Pathways program is a membership training route to enable people to get experience in the different fields of ADR. So that's the pathway now is what I was explaining, how you move from associate member, fellow, and subsequently, hopefully, to chartered. This is the pathway. As you can see, for you to be an CIArb, you have to do one of these four, either introduction to domestic arbitration, there's also international arbitration, adjudication, and mediation. The pathway is this, you can see it's a path. So you go introduction, then you do module 1, then you do module 3. Then when you finish module 3, that's when now you can become a fellow. You can become a fellow either in domestic arbitration, international arbitration, construction, mediation. You can become a fellow in all if you want. Like me, I think, yeah, I'm close to fellow in both arbitration. I'm just at the last stage, arbitration and mediation, because I'm already accredited. I'm past this. So that's MCIArb. And regarding module 2 for lawyers, you can decide to go through the training, that is do the tutorials and then subsequently do the assessment and the exam, or you can decide to do the exemption paper for module 2 for lawyers, because law of obligations is basically tort, evidence, and contract law. Also, apart from the pathways now where you've reached to fellow, CIArb also offers like continuous training development for professionals. You can see there are e-modules in award writing, because sometimes you also need a refresher course, or you're even just interested in that. You don't have perhaps to be so keen on the pathways. Avoiding and resolving contractual disputes, brand protection in times of disputes. You can see the online introduction to ADR. Maybe you just want to have a basic understanding. There's also a book that was launched last year, the audio book. There are also courses in development, as you can see, arbitral secretary training, because sometimes you want to understand the role of an arbitral secretary. And an arbitral secretary basically is a person who sits with the tribunal and assists the tribunal. There's also expert witness training, because the thing with the dispute resolution, I'll say spectrum, is an arbitrator, a mediator, a construction adjudicator, but then they are also supporting people who also come to support now the entire process. That's why you see there's arbitral secretaries, negotiation as well, which there is no pathway, but negotiation is also a recognized form of dispute resolution, that is ADR. Expert witness also, because sometimes when you're doing arbitration or construction adjudication, there's experts. So that training is also available. These are the offers now, the hot offers of the kitchen. Yeah, you can see there's a lot of subsidization in terms of courses. Like you can see this is 25 pounds, I think that's around $40. And once you do this, you can see there's a waiver here, because you have to initially apply to be a formal member of CIArb once you pass your entry course. You see this waiver of £90 has been given to student members. So this is fantastic, and I'd advise everyone to do this, because by the time we were doing this these entry courses, I think we were paying around £1 to £50. So this is fantastic. 25, I even feel like doing it. 25, as you can see the requirements, of course, you have to have student membership, you have to provide valid student ID as proof. So that now you cannot have non-students taking advantage of student offers. Now, once you've done that introductory, once you've done the introductory, if you decide to take advantage of these offers, and then now you apply and you get the exemption and become a student member, as you can see, these are other courses also. If you decide to take on these courses, you can see they are reasonably affordable. I'll tell you, it might look like a lot of money. I did these courses when I was a student, so it was terrible for me financially. But the return on that investment is something that you cannot tell people who've not gone through it. So take your time to go through these slides and decide which you think works for you. Then, as you can see, also the professional development courses, as I said earlier, these are also e-modules, and you can take on them, and I can assure you that they are usually, CIArb courses are quality, top-notch. I know it sounds like I'm selling CIArb, but it is the truth, because I have interacted in the ADR world enough to know what is good and what is not, and I can say this is good. Now, perhaps the difference I can say between virtual and online introduction, you can see the online courses are cheaper. It's because online courses are self-study, so you do them at your own time and finish. Virtual, it's basically the same class that when we had physical training, it's basically the same class with a tutor and everything, but then now this one is being done virtually, like online. So that's why I guess it's a bit, because yeah, it's not self-study, so, and you know, tutors have to be paid also. We have a practice and standards committee, which basically, as you can see, it involves, the committee sits and establish guidelines of good practice, because you see the dispute resolution platforms keeps changing. Like last year now, when the pandemic hit us, unfortunately, CIArb, the committee sat and came up with guidelines for how to conduct hearings online. We also have a code of ethics, which the committee has come up with, so that you see the people who carry out dispute resolution, that is ADR, have a code of ethics, so that the standards. There's also the principal rules and procedures for the practice. You know, we have CIArb rules. So that is basically the work of the committee, to state standards and at any given point come up with protocols, guidelines, and rules to contribute to the dispute resolution space, and also to guide its members in their practice. As I said, we have book, journals, papers, and reports. This is the resolver. It's usually sent online nowadays, and it's on the website. So if you're a student member, you can access it. And then there's this, I'm trying to say, the journal, the one I said is a top-notch journal. There's this. We also get newsletters monthly to update us with short articles and also developments within CIArb and the general arbitration world. Now, with the revamp of the student membership for CIArb, because at some point I can admit there was a small go slow, not go slow. Basically, we were not very active for a few years on the student membership issue, but now it is back with a bang. As you can see, there'll be an official launch in March 21 of the ADR Student Experience Program. This will be a joint partnership between the Chartered Institute of Arbitrators and Careers in Arbitration. So this will basically be a practical mentorship experience, and more information will be given to people. As you can see, once you get the slides, kindly join as a student member and register your interest on that link. As you can see, Careers in Arbitration, and if you go and check LinkedIn, Careers in Arbitration is one of the foremost sources of information for young practitioners seeking to get into the field. And the CEO and founder was a former chair of CIArb Young Members Group globally. So this is a really good experience, and I would really ask you to diarize and wait for the actual dates to come out, and be sure to attend to get the benefits of this collaboration. So having said all that I've said, I'll just tell you this, please join CIArb. And now you're lucky that you're able to join as a student member just with a click. There's also a YouTube channel. Follow them on LinkedIn, Facebook, Twitter. And to become a member, just go to CIArb, just even Google Chartered Institute of Arbitrators membership. That is when you'll get the links of student membership and all this information I've told you. Listen to the YouTube channels. They post, when they have webinars and talks, they're posted there. And sometimes even members are, experienced practitioners are interviewed. So don't let this opportunity pass you. Start early. I will say, since I have a bit of time, I'll just take 2 minutes to tell you, I joined CIArb when I was still a student, and it's been a 10-year journey, and CIArb was the launching platform for me when now I started getting involved in ADR. So the earlier you join, the better, and it is not just limited to lawyers. So I think I will stop my presentation there, and open to questions from the audience. Okay, I'll answer the question on Nairim Bukan. I hope I pronounce your name right. If I butcher anyone's name, please don't take it personally. So this question on I have gained mediation qualification from FRICS. Is that acceptable to request fellow membership and arrange for interview? What you can do, from what I understand, showing your experience, what I was trying to say, basically the difference between training and assessment, you need to get in touch with CIArb, what can I say? Education and training, yes, department. Then now after that, they will tell you what they would say is an equivalent of the training from RICS, so that they tell you at what level they'll assess you. So I would advise you to go to the website and look at education and training, and I know that there's a link to reach the education and training department. They will guide you on what assessment you may need to take, and of course they'll have to know at what level and what course content was taken at RICS. Yes. Next question. What from Shanfeng? Your first name is hard. I started these courses as a student. What motivated me to start these ADR courses when I was a student? Okay. I attended a basic, in university, we were taught a basic course in alternative dispute resolution. So I was like curious about it. I Googled, and eventually I found out that the only place I could train in arbitration and mediation in Kenya was in Nairobi. I didn't go to university in Nairobi. So I just came to the Chartered Institute of Arbitrators in Nairobi, and I did mediation, arbitration, and then construction adjudication. My motivation, apart from just curiosity at first, was because a part of me knew that I did not want to practice the normal litigation, just normal court farm work. So I saw this as a new thing that had not yet caught on. So I said, let me jump on the train before everyone jumps on it. And that has been good for me because it makes me generally an all-round dispute resolver, because I can still do litigation. So yeah, just start now. Even if you don't later become you don't decide to specialize in it, it will come in handy for you, even in terms of just knowledge and also expanding your opportunities. Thank you for the questions. I'll just keep answering them. Regarding student membership enrollment, is that only applicable or open to full-time students? No, you can be a student member so long as you show that you are currently a student, like as you can see most LLM, like I can see the next question. If you're a professional working student, you can still apply for it so long as you furnish a letter or something showing that you're a student member. The presentation will be shared via email in the next few days. There's also a link on the student membership in the chat. Kindly log in. There's also a question on what are the ways to apply for mentorship opportunities. Well, I will give this example. I will answer this as an example. It is easier for you to get mentorship from a CIArb member if you're a CIArb member, such that if you're a student member or a young member, as I said, we all attend the same events with fellows and chartered arbitrators. So over time, you start knowing the circles, and it's easier for a CIArb member to meet you to meet a CIArb member and ask for mentorship. The thing with mentorship, I will say, is it's easier to mentor someone who has shown initiative. So if you're a member of CIArb, even if just a student member, even the fellow or the member or the chartered arbitrator will see that you've actually shown initiative to ADR, to join ADR, and so you'll get mentorship. Like I got mentorship off a cocktail, and that's all my mentors, I met them in one cocktail, and they've stayed with me even now. Through the young members groups also, when you participate in events like, say now, as we've said, as a student member, you participate in writing articles, which will be published in the essay competition. That also puts you on the spotlight, so that potential people will be curious as to who is this young member who's writing nice articles or who participated in the essay competition, because I wrote my first CIArb published article when I was a student member. So you just have also to put yourself out there and take advantage of the opportunities that you will get as a student member. Is there a huge demand for arbitration lawyers in the UK? Well, as you, since it's a student forum, I will just say the leading hubs for international arbitration, and this is not my personal opinion, I'm just basing it on statistics that have shown even between Queen Mary, University of London studies, and all these studies. London is the leading seat. Seat to mean people like picking to do their arbitrations, like they like picking London as a place to do their arbitrations. London, Paris, and say maybe Geneva. So with London being the hub, one of the world's leading hubs of arbitration, there will always be demand for arbitration lawyers. Just check on LinkedIn. Everyone is trying to convert their qualifications to the UK ones so that they can go and practice arbitration in London. London is the hub, so UK, there's a demand, and I think increasingly there'll be more and more with opportunities opening. The demand for arbitration lawyers, I think, is there. Isabella, you've been answered your question with the email education@ciarb.org. Just email to learn more about how the virtual courses are conducted. Is there a maximum period that one can be a student member? You have to be a student so that you are a student member. Once you cease being a student, it is best that you now exit for other students to take advantage of the student membership, because the opportunities that are offered to student members are so that they get a bit of mentorship and networks so that they upgrade to associate member. That is the whole purpose. And that is why you can see the student members courses are subsidized. So once you cease being a student, yeah, you will have to let others come in and take advantage. So take as much advantage as you can now that you qualify for student membership. Yeah, I think I'm done with the questions unless anyone else has a question. And yeah. Questions? Is there a time limit for courses? I don't understand the question, but time limit for courses. Yes, connect with me on LinkedIn. Add me on LinkedIn. Also, I forgot to say that we can talk and see how I can help in mentorship. As much as I'm busy, yeah, I always find time for students. I'll respond. Time limit for courses. You see how the courses are structured? It's like in uni. It's just that these are professional courses. So there's a time period. Tutorial 1 will be on this date, tutorial 2 on this date, assessment on this date, exam on this date. So it has to be done in a structured way so that there is a semblance of order, because CIArb can't be training people at their own time. Because it's a training institution. Yes, if you're living out of London, student membership is for everyone. We have student members in Kenya, Saudi Arabia, Iran, wherever in the world you are, you can join as a student member. You don't have to be in London. In fact, majority of student members are not in London. So anyone can join from wherever in the world they are, so long as they qualify. How long will it take a student member to get a postnominal letter accreditation for associate membership? As soon as you pass your entry course and apply for the exemption, CIArb does not keep people waiting. Yes, as soon as you pass your online courses, the ones that we said, the introductory courses, apply for exemption, it shouldn't take more than a week. And that is saying, yeah, that is CIArb. As for the online courses, as I said, as you can see in the chart, online courses are at your own pace if you're worried about time limit. But if you want to follow the CIArb training pathway for the virtual courses, those ones will have time limits because they have a tutor who trains people, and a tutor can't be training people at different times. Yeah. So I believe people are satisfied. The slides will be circulated to the attendees. And thank you so much for attending and for the good questions. Since we finished this panel early, this is 12:36 GMT, I will give a 9-minute break so that we transition to now the panel discussion, which will be exciting. At least that time I will not be reading slides, so it will be more interactive. Keep shooting the questions even as the panel is speaking, panelists are speaking, so that, sorry, I'm just typing my mail address, so that the panelists can also have a more interactive session. So we'll take a break now, and then I'll see you in the next 9 minutes. Yes, thank you so much. Don't log off. Hi, everyone.
Hello.
How are you feeling?
Good, thank you.
Still in winter. I hear it's snowing heavily. Let's close this. 1 second. Okay. Okay.
Change my background, really. So.
Decide which one. Or you'll keep switching up on us.
Can you read the words the right way around, or are they backwards?
No, that's
the right way.
Yeah, it's always tricky because I see it the wrong way around, and it's like just checking.
It's looking good. So yeah, we can start the panel. Welcome everyone to our panel session. Sorry. I'll begin by introducing the panelists, and then I'll ask them questions, which they will answer. And then, as I said, we'll have a Q&A after this session. And I expect you to ask questions. We'll try and answer as many as we can. So ask the questions in the chat. And if there's a specific panelist you'd like to address the question to, kindly write that against the name so that we can direct it accordingly. Now, with us, we have, first of all, I'll still give my disclaimer. I pronounce my names in a Kenyan accent, so I may not pronounce them the right way, but so long as you can see the real name on the screen. I'll start with Veronika Pavlovskaya. I know. She's a senior associate at Azinga Law Offices, and she's also the chief coordinator at Young ADR in Belarus, which is a project for young arbitration practitioners. She specializes in dispute resolution and technology law. She has also been involved in advising transnational corporations, unicorn companies, and startups regarding their day-to-day activity, government relations, and data protection. She's also a legal tech enthusiast. I like this part. Basically, she has a very keen interest, including as around the use of technology in dispute resolution, and therefore she takes part in legal tech hackathons. I attended one where I failed, but now I have Veronika, she can teach me. She attends these hackathons as a mentor and participant. She's attended the advanced course in international investment arbitration at the Arbitration Academy in Paris. She's also done an internship at the ICC Court of Arbitration and did her LLM from the Queen Mary University of London as a Shevling scholar. She's also involved in various educational and mooting activities, in particular the VIS-moot and multiple pre-moots. Pre-moots is the pre-moot before the moot. As a moot participant herself, as an arbitrator during the moot, and she's been coaching teams since 2015. And she's a member of CIArb. We have Richard, who's a chartered surveyor with 20 years of experience in the construction industry. He has 20 years, of course, is extensive experience in construction. He's also trained as an expert witness and has recently provided quantum support on several high-value claims to a range of forums, including a major loss to a UK power station and many others, which I cannot name because there are many. He's also a registered arbitrator on CIDA and the Chartered Institute of Arbitrators panels. He also regularly carries out consumer adjudications and arbitrations for CIDA on its home building and residential schemes. Further, he's also a CIDA is CEDR, CIDA accredited mediator. He's also an accredited tutor for the CIArb on its pathway models, just like me, modules. He has recently collated and adapted the content for CIArb's first audiobook, which I spoke about earlier, and helped to develop the ADR for business module. He is the immediate past chair of the CIArb Northwest branch and was recently elected as a trustee of the Chartered Institute of Arbitrators. Again, as I said, CIArb is a charity, so he's one of the people at the top handling our business. In that role, he seeks to ensure that CIArb continues to create opportunities for younger and new members of the Institute in both arbitration and other forms of ADR. Last but certainly not least, I'm reading the short profiles because these profiles could have been longer, but now we want to have the panel. He's Artem Doudko. He's a fellow of the Chartered Institute of Arbitrator, a solicitor advocate, and is a partner and head of Russia and CIS disputes in the London Disputes and Risk Practice at Osborne Clark. He focuses on international arbitration and litigation involving Russian and or CIS issues, as well as advising Russian-speaking clients. Very strong reputation and profile in his field. He has been recognized as a global leader in the Who's Who Legal Arbitration 2020 directory. This is basically leaders in arbitration. They are listed every year. He's also been identified as a next general partner and described as a sharp-minded litigator and as very experienced in Russia and CIS-related arbitrations in Legal 500 UK 2020, which is basically a listing also in the UK for the top legal practitioners. Further, he's a member of the ICC Commission on Arbitration and ADR representing Russia, and a member of the membership committee of the Silicon Valley Arbitration and Mediation Center. I joined this initiative recently, and so far it's interesting to me. So, having introduced the panelists, I think I will go quickly to the panel session and ask questions each panelist. One panelist will basically start by giving their views, and then another one will respond by basically adding anything else that they think will be useful for the students to learn or to get from that topic. So I'll go with the first question, which Nika will be the lead, and then Artem will comment. This is my question. Now that we've known that you've participated widely in moots as a mootee, as a coach, as an arbitrator, with the V-Spring moots coming up and having been a participant, what benefits would you say there are for students to get involved in moots and opportunities to further their careers? And also, what are the tips for those who take part to excel? Take it away. Thank you.
Good afternoon, everyone. Thank you very much, Mercy, for your wonderful presentation before this session and for a very kind introduction. I'm glad to start this panel with the question about the VIS moot and moot courts, because I'm a big fan of moot courts and I believe it's a brilliant experience for any student. And I will shortly list the reasons why I believe so. So definitely the first reason is that taking part in the moot court is actually one of the closest experiences to the real life that you can have being a student. So when you're taking part in the moot court, you need to do the research, you need to draft memorandum, you need to present your position to the tribunal. So that's exactly the activities that you would do in future being a dispute resolution lawyer. And taking part in the moot court allows you to feel and to understand if you really want to be one. That's very important when you're a student, because normally at the uni, just attending lectures, you don't have the opportunity and the chance to feel the job, how it is to draft this memorandum in the night or the night before the deadline. It's just something you need to feel, and moot courts can help. Then second reason is, of course, teamwork and networking. I would not lie if I say that moot courts, they are equally about the law and about the people. So it's the way to meet other people, to meet your teammates, to try what does it mean to have a teamwork and what does good teamwork means. And then, of course, you can meet your coaches and arbitrators, and potentially it can be your perspective of employment. And of course, it can be another opportunity for you. So taking part in the moot court is really a good chance for your future career. Then the third point here is, of course, a good point for your CV. Because if your potential employer can see that you have taken part in the moot court, it means that you are dedicated, it means that you're hardworking, it just shows that you have the necessary set of skills to start your work as a legal assistant or junior associate. Then, of course, the fourth, the last but not least for me for today is, of course, having a lot of fun. Because moot courts is about meeting people, it's about social activities, and if you can allow yourself to skip maybe some official events or to find some time in your preparation and to go to some social events, then probably you can have one of the best memories of your student life there. What is very good about the moot courts is that they will not finish in your life after your graduation. For example, you can become a coach or you can become an arbitrator, you can still network, you can still socialize. And that's my story. So I just transferred from being a mootee to being an arbitrator. And as we say it in the VIS moot, once a mootee is always a mootee.
Fantastic. Artem, anything you'd like to add to that?
Well, I would say, I mean, as a short comment, I agree with everything Veronika has just said. I think when I was a student, we did have some moots at university, but these were to do with litigation, and we didn't have the arbitration moots, and in particular the wide intra-university ones. So I am really disappointed to have missed out on that opportunity. And the first I heard about arbitration was at law school after university. So I would say this is definitely an opportunity to get involved early on and to find out if this is for you or not. So definitely take this opportunity. In terms of a top tip, it's the one bit how mooting is different to real life, because something that I really agree with Veronika about is that it's the closest to a real life arbitration that you're going to experience. But the one difference is that during the course of one competition, you get to argue about the same case over and over and over again. You do it at the pre-moot, you do it during the different rounds of the main moot. And so you argue about the same case over and over around. In real life, we only get one opportunity to argue the position. And so that my top tip linked to that is actually take advantage of the situation, and particularly in the earlier rounds of the pre-moots or even the main moot, try different things, try different strategies, different approaches to see what works, because you're not going to get this opportunity in a real life dispute to rerun the arguments. So learn through the mooting experience. And I think the final thing to add is that, to my mind, the arbitration community is probably the most social one amongst lawyers. And because of that, I sometimes feel sorry for our transactional colleagues who don't seem to have an opportunity to get together. And clearly with the arbitration lawyers, this starts from the mooting experience, which is very social, very collegiate. We always like to get together to talk about arbitration and just to meet all the different personalities and characters within the world of arbitration. So get involved, completely recommended.
Awesome. And I totally agree with the point on taking advantage of arbitration moots, because even when I was in uni, these moots in arbitration were not there. We just used to do the litigation moots. And also potential employers might be sitting as arbitrators and coaches. And if you showcase your skills, these internships and mentorship opportunities that people keep asking for. One of my younger colleagues that I know participated in the VIS moots. They did not win, but someone from the University of Geneva Meads was there as one of the arbitrators, and actually they reached out to them and offered them a scholarship in their LLM. So those are also places to showcase your talents, and you never know who is watching, because the professionals are there, actual practicing people. Now, next question. This will be Richard's question specifically. As the only non-lawyer on this panel, yet you have excelled in arbitration, what would you say are the prospects of a non-lawyer excelling in arbitration and mediation? And is the market open to non-lawyers really outside of construction adjudication? I mean, what has been your experience? And then Nika will comment anything else she might want to add. Thanks.
Sorry. I think that arbitration and mediation are increasingly becoming mainstream forms of dispute resolution in favour of ADR, especially when businesses look to resolve their disputes with customers. Obviously, within Europe, there has been guidance from the EU that companies have to provide alternative dispute resolution platforms. Perhaps one of the best and most recognised forms of arbitration in the UK actually relates to holiday arbitration, and that's under the ABTA scheme. So where a particular person would go on holiday and they'd have a dispute with the package provider, they could, on their return from their holiday, elect to resolve that dispute to arbitration, which they can do from the comfort of their own homes via documents-only procedure. That's where I started my practice in arbitration, and then moved on to other schemes such as home building, residential, and complaints against surveyors. And I found that it was a great opportunity for me to consolidate my own learning and obviously regularly produce reasoned awards, which is something that, as a practitioner or an advocate of one of the parties, is something that you wouldn't do. As to the prospects of future opportunities for non-lawyers and even lawyers, I think the potential is huge. You know, eBay's own ODR platform, apparently that handles approximately over 60 million disputes a year. So, you know, in terms of potential for ADR and opportunities for young people and new practitioners, you know, the world is generally your oyster. And I think it's important, though, that as a sort of a new practitioner, that you manage your expectations. You know, you need to realise that you're going to have to work from the ground up, and that everyone will get the opportunity to work on a multi-million or multi-billion-dollar arbitration, maybe on the first assignment or even at all in their career. But that's not to say that one particular dispute process, you know, is more or less important than another. You know, you're affecting, you know, these disputes have an effect on people's lives of varying degrees. I think hopefully that answers your question.
Yes, I think you've answered it very well. And Veronika, what would you like to add?
Actually, I would like to add that there are a lot of roles right now in arbitration for non-lawyers, and these roles are connected, for example, with expertise in quantum, which is like a very usual thing for every arbitration. And thanks God and kudos to all the experts who do this work, because otherwise it would be our obligation to calculate all of this. And it's, I don't know, for me, I can't really understand really well how it is calculated and how it should be calculated. So thank you very much to them. And if you like numbers, it can be really an option for you to jump into arbitration. And what also can be an option, and it's like the future of arbitration, I believe, is ArbTech. So everything which is related to technology, starting from probably some programs from some software that we have now for arbitration, like relativity and everything else. And go into development of the machine arbitrators and development of the data sets for machine arbitrators, taking part in the proceedings to make them work and to explain to the other participants how they actually work. That might be another option. For example, for the graduates of the STEAM courses at the universities, it's just a good opportunity to become very, very close to arbitration or just jump into it.
Awesome. I've also learned something. Now I'll start researching on how to do tech things in arbitrations and not sit as arbitrator. Okay, great. Next question. Artem, kindly, as a seasoned practitioner, what tips would you give to students looking to apply to firms, including international students, even international young practitioners, either to join firms as interns or associates in arbitration firms? Kindly take the lead on that, and then Nika may comment with anything else she wishes to add. Thanks.
Thanks, Mercy. Obviously there's a lot to say on this topic, so I'll try to give some comments, and maybe we can have a bit of a discussion about this. I think the starting point has to be that students need to go into this with an open eyes about just how competitive the market is. There are a lot of very good students who are trying to get the jobs available. So if you have to be prepared for that competition, and you have to demonstrate why you are the best candidate for the job. And now there are different ways of doing this. I think being involved as a student member in CIArb activities is one way of getting to know the different individuals within the arbitration community, if arbitration is of interest to you. But also, I think, speaking very frankly, I think we need to be aware that amongst all the legal jobs out there, arbitration and dispute resolution is, if we are talking about legal jobs, and Richard can add about non-legal jobs involved in arbitration, but legal jobs, arbitration is a small part of what lawyers do. And if you're applying for a starting position at a law firm, for example, a training contract, then you need to appreciate that most law firms do a whole number of different types of work, of which arbitration is a small part of it. So you have to be careful at that stage in your career not to overemphasize that you have made your decision already and you know that arbitration is the one and only thing that you want to do. I think you should be open to getting the initial job first of all, going through the programs offered by law firms of trying different departments, getting different experiences, getting the basic skills right, and then, provided you still think at that stage that arbitration is for you, at that stage starting to become more specialist. So because if you don't do that, if you do from the outset say that arbitration is the one and anything you want to do, I think you will limit your opportunities even further. So that's a kind of an honest bit of insight. I think you have to bear that in mind. Knowing the right people, very important to help you to understand how the market works, where the job opportunities may be, because at the end of the day, it's being in the right place at the right time. And for example, my very first job many years ago happened because someone was working in a dispute that involved a Russian case, and they needed someone junior to help with the documents. I was still a student at university, but because I had been in touch with the law firm, I'd spoken with the partner who was doing the case. He remembered me, and so he reached out and said, by the way, do you want to help out during your holidays with us? Of course, I grasped the opportunity, but that's to be able to put myself into that position. I needed to first of all make contact with law firm, go to the open day, meet the relevant person, so that they would be aware of me. So be opportunistic and create the opportunities for yourself. And then the final comment before passing on, which I think is really important, is if you are going to say that arbitration is something that you're really interested in, and I hear this statement very often from junior lawyers, from students, I'm going to test you on this, not in a very serious way, but I'd like to at least understand the basics of what is arbitration. Give me an example of a recent case about arbitration. How is it different to litigation? Say something sensible about what it is that attracts you to arbitration. Don't just say that you like arbitration because you think that's something I would want to hear, without having the backup to explain yourself. You will only look silly, and that would be the end of that conversation. I can go on, but I'd like to hear the others as well.
I believe it would be very cool if you could go on and share some more pieces of advice, because they're really invaluable for students, I guess. I will just follow the idea on knowing the specific features of arbitration when you're saying that you're really interested. Actually, you need to show who you are, because all of us know that, yes, we need to write a good CV, we need to write a good cover letter, but every law firm gets thousands of these applications and all of them are good. You need to make it outstanding. You need to show the personality, and the personality is what I believe the law firms are looking for. So you need to show it in your documents and during your interviews. And that's exactly what can show your appreciation to arbitration and your interest. And another tip from me is don't lie, because when you're lying in your documents, it's terrible. We had this situation when once we got the CV and cover letter from a guy who was very nice. He had good qualification, like literally everything was fine, except from one moment. He stipulated that he was a member of the Vismo team of the BSU in the year, let's say 2017. And the funny thing is that I was coaching that team and I had no idea who this guy was. So unfortunately to him, he chose the wrong year when stipulating his participation in the Vismut. And you can understand that he did not go to the interview with us. So don't lie, be fair, and better take part in the moot court in the real life and just then put it to your CV.
Great. I was really laughing about the lie bit, because you see, as a lawyer, integrity will be expected of you. So even if you don't get that job, there is a chance of meeting that same person in a different role, and they'll always remember that you lied about something 25 years ago. And I really agree with Artem on the issue of testing. You see, when you're practicing as an arbitrator or mediator, and there's always someone younger than you can teach something, people will always ask you for mentorship. How I mentor people, I'll send you links to webinars, or I'll tell you, write a small article on this issue. If you really want to be an arbitrator, you better act like one, because I can't be spoon-feeding you. So show your initiative so that if someone is helping you, at least you've brought yourself to a certain, at least you've left the house. Now you can come to the car, but you are in the house in bed and you want to be in the car. It doesn't work like that. And you see, as you've heard, the field is competitive. And also in terms of culture, firms, every firm has different cultures. If you have opportunities to attend open days, that is how you'll know the culture of the law firm. But now if you don't expose yourself, you'll go there and you find the culture is not a good fit for you. So yeah, that's what I'll say on that. This is the last structured question per se. And Artem will take the lead, Richard will comment. Now, with the increased use of technology in the pandemic and both of yours extensive knowledge and interest in technology, artificial intelligence, do you see the increased use of technology in ADR moving forward? And what do you think are areas students should look into if they share the same interests alongside interest in ADR? I think actually even Nika, you'll say something on that because I know you do that. So Richard, Artem can start, Richard will second, and then Veronika, you can add. Thank you.
Thanks, Mercy. I mean, the short answer is yes, of course, technology is becoming utilized in arbitration as in most other disciplines. And I think we've seen that in particular during the last year, during COVID. Arbitration hearings have taken place predominantly over video links, such as the one that we're sort of using at the moment. Obviously, that has meant the use of electronic documents. So there's been a lot more sophisticated document management systems that have been used. But technology in ADR and arbitration has gone a lot deeper than that. There are, for example, you can get advice on choice of the right arbitrator for your case. I understand there's different projects for helping to use experts in a particular arbitration. There's the usual sort of document review platforms and electronic evidence gathering systems. And I think all of these will only develop, and there will be a greater use of technology in arbitration. And in terms of the skill sets that junior lawyers should have, we're actually sort of at my firm, we're having quite a few conversations about who will we be looking for to join our firm and say in the next 5 years time, what sort of skills would we want the people to have? And I think the legal knowledge and the legal expertise is a given, but it's clear that the second group of skills that we will be looking for is the ability to use all the different technology that is getting more and more sophisticated. So I don't think there is, well, separately, there is an opportunity, we think, of potentially a new profession of technologists who will work with lawyers, including in arbitration cases. But if you're going to be, if your career is set on becoming a lawyer, then being good with technology is a requisite. So try to understand how the different programs work if you get an opportunity. Use them, be familiar with them, be generally technologically switched on. I think that will be an important part of what we are looking for.
Richard?
Hello. So yeah, so I agree with Artem. I think this is a fantastic opportunity for the younger generation to dominate and control this particular market. You know, you've all grown up with technology. We perhaps it came later on in our teens, but you know, with that transfer, even just handling data is now you know, a task on its own, especially with the large volumes. You know, we used to go from bankers' boxes of files to now a SharePoint or a whatever link, and then being able to try and extract the information from that particular link. As you become more conversant, you can get quicker and better. But again, the technology is evolving all the time. I think you're going to find that as time goes on, technology is going to become even more important. And like construction, it's been subject to a lot of disputes in this past. I suspect there's going to be a lot of technology disputes going forward as well, once those systems start to fall over and people start pushing the boundaries. So again, lots of potential for people, individuals, you know, whether you're a technologist or a lawyer, you know, to provide that expert witness and those support functions to the tribunals, and even to sit on the tribunals, because obviously not every arbitration panel, you know, is constituted by, you know, 3 lawyers. You know, it's that range of skills, and that's one of the, perhaps the beauties of arbitration over litigation. You know, you can have business people deciding business disputes if that's what's obviously required. Thank you.
Yeah, and I will pick the question from the chat, because we got the question from Philip about the knowledge of the particular sector of technology, if you want to deal with technology disputes. So do we need to have this specific knowledge if we are basically dispute resolution lawyers? Well, my answer is yes. That's what I believe, because if you want to specialize in something, you need to understand not only the procedural side of the scenes as an arbitration lawyer, but also the substantive part of the scenes. And that's why you need to know the particular sector of technology. I came through this choice personally because I did my LLM in technology law, but not in arbitration law at Queen Mary. And that was on purpose, because I saw that I need to know everything in detail about technology contracts to deal with the technology issues. So the same about data protection, the same about artificial intelligence. So that's what I would recommend to do. And my final comment on that is that another area that is very important when we're speaking about technology is ethics. And I can't help addressing the recent case with this cat filter on the screen in Zoom during the proceedings in the US. And here it's about ethics. Of course, it looks hilarious, but when you think about it, so the first scene is that there was a clear sign on the screen that it's prohibited to record this session and to distribute it. And you know what has happened. So that's the first ethical issue, how you behave. And it was someone definitely from the participants of that meeting. The second issue here is the behavior of the judges, actually, which was brilliant, because they were calm, they just tried to help, they were very professional. And that's what we should think about when we're working with technology, because it takes time to learn. Sometimes different strange things happen to all these technology things, and we need to be very patient and very professional. So we should not forget about the ethical part of this technology development. And it's very important for young lawyers to look from this perspective as well.
Great. I'm also learning. I said I'm also learning. That Zoom cat thing was hilarious, no, but now when you brought in the ethical part, I feel guilty for enjoying it thoroughly. Yeah. Now, quick breather, panelists, I will ask you to give me your best smile. I'll take a panel picture, then we move to the next round of questions. So oh my, see, I'm struggling with technology already. Okay, here we go. Okay, I've taken enough. That's good to go. Now, the next round of discussions will not be so structured. So every panelist will just give their comments, short ones. So that's now we go to Q&A. This is the order I'll do. You'll answer the questions in. So from where you appear, from my end of the screen, it's going to be Richard, Veronika, then Artem. So the first question, what are your top 3 tips for students looking to have a career in international arbitration, mediation, or whatever, basically international alternative dispute resolution? Top 3 tips.
So I think my first tip would be to get involved with your local CIArb branch and the young members group. That'll obviously open up those opportunities to meet people who are involved in arbitration. You'll obviously consolidate your learning through that process and gather new learning. I think the second one would be prepared to put the work in. Obviously, you'll get in what you put out, or you'll get out what you put in. And then the third one, which I think Artem touched on earlier, was obviously be prepared to consider other opportunities and pathways, because, you know, this is a niche, and you may not want to pigeon yourself so soon, so early.
Yeah, I would say that my 3 tips are be a good lawyer, be professional, have good knowledge, because no one wants to have a bad lawyer, just let's be fair. Then second tip is be visible. As Vladimir Khvaley always says, so to make you seen, you need to jump higher. So that's why the other practitioners should know you. And the third tip is be persistent. No matter what happens, good or bad, you just need to continue working and working during all your life on your professional qualities, on your reputation, and everything will be good in the future.
Going third has its disadvantages in this particular exercise because all the good things have been already said, but I'll add a couple if I can. So one, hard work. We're all looking for those who are prepared to do the hours, to do. It's not an easy job. It requires commitment. So one, be really sure that you want to do it, but if you are, then put in the hours. Second thing, common sense. I think that is something in particular that I really think is really important. I want to work with people that have common sense and can think for themselves and have their own ideas and proactive and all of that. But the starting point is have common sense. And then the final thing that hasn't been mentioned yet as well, I think, is make sure you have an up-to-date LinkedIn profile, maintain it, and connect on LinkedIn, publish articles on LinkedIn, get involved in different groups. But I think LinkedIn is a very useful tool for raising your profile within the arbitration community.
Awesome. I'll say my tip is, I'll say a quote. Basically, I'll give a quote. Don't say anyone is lucky. Luck is when opportunity meets preparation. So that is just my parting shot. Be working on your expertise, on your skills as you look out for opportunities. Because if there's a $1 billion dispute that people are looking for an arbitrator, if you're not a trained arbitrator, no one will give you the matter. So you have to, preparation and opportunity, when they meet, that's when you can say it's luck. Luck, the only luck is in a casino. Everything else, it's hard work, and you have to stay prepared and look out for the opportunities. My next question. This is just me, actually. I'll switch up your questions. I told you I'll be a cheeky moderator. So this is around young practitioner groups in ADR. Today being a Student Open Day, we were discussing the issues of the Young Members Group, which is the Young Members Group, basically grouping, organization, or whatever for the Chartered Institute of Arbitrators. However, we are aware that there are so many young members groups nowadays tackling issues of ADR to ensure younger members join the field and they get the opportunities, networking, mentorship, etc. At some point, I think we've all been involved in young members groups. Personally, I feel like mine is actually a full-time job, but I enjoy it. I'm in too many and I attend events and they're very helpful. However, do you really think, what do you think is the purpose of young members group like the CIArb Young Members Group in molding and assisting young practitioners gain experience? And is there anything you can say you have gained by being a member of these young member groups? Richard, Dika, Artem.
So I mean, they definitely open doors for you. You obviously get to meet people outside of your region. You know, so I've been obviously down to the CIArb Young Members Group in London. We've been to the ICC in Paris. You know, opportunities that you wouldn't normally get. Fortunate enough we had a visit to the Houses of Parliament, I think back in 2013, and a talk by Lord Goldsmith. Yeah, so like I say, it's forming relationships, and you know, it's those people that you will contact later in life and hopefully maintain those relationships. You may not speak to them every month, you may only meet them from year to year, but you know, those people are there to support you as well, you know, especially when times get hard.
I agree to Richard, and yeah, I agree that there is a good educational opportunity for the students and young practitioners to take part in the events organized by the young member groups. It's also the good thing for networking that we have discussed earlier. So you just meet people, you know people, and it's a way to get the speaking engagement as well for young practitioners, because if you start speaking at the conferences for young practitioners, then you meet people, you can be invited to some, let's say, adult conferences. So it's a good way to start your speaking career. And it's also the open door for your own projects, because the young members group, they are always open to any creative ideas you may have. And it's sometimes quite difficult to bring these ideas into life with, again, professional experienced organizations. So you can go to the younger group and you can just propose and say about your idea, discuss it in detail, and then bring it into life.
And to add a couple of comments that haven't been made so far, try not to just to attend, but actually try to get it actively involved and join a committee and try to contribute to the activities of the young member group. And then the second comment as to why is it worth it? Why do you do all of this? Well, like as we all start as very junior lawyers or at the start of our legal profession. We join initially the young member groups. You amongst your peers, you develop the relationships. As you progress with your career, those who you've met at the young member groups also progress with their careers, and eventually you all sort of move forward, and your career moves to a position where you become ultimately a decision maker, as do others. And by having those really trusted relationships, good relationships, where you really know who the people that you throughout, you could always ask the silly question and get the really helpful answers, are the ones who you will probably recommend to your clients when they need a relevant advisor where you can't do the work yourself. So it's a long-term process, but that's how you build the trusted relationships that you then later on in life rely on and support one another and build your ultimately successful careers out of it.
Awesome. I'd also say truly my involvement, extreme involvement and activity in young members groups, for me, it has been career changing, because I've actually made lifelong friends, like real friends. And we just met online. One of them will say that joke one day publicly. She's very famous and we've never seen each other physically in one room, but we chat all the time. She knows everything, almost everything about me. We've become very good friends. And actually my first speaking engagement in an international conference came from a fellow young member that I met in a young members group. My first 2 arbitral appointments as sole arbitrators came from young practitioners. So there's always something to, worst case, you can also meet your spouse. The opportunities are unlimited. It's worth it. And I think it's very important if people get involved. My last question before we go to panel. Now, this is the cheeky one. And don't lie. What is your biggest regret or mistake you have made in your ADR practice or journey? And what are the lessons you learned from it when you look back?
I think for me, it's not joining CIArb earlier. I joined quite late in my career, having completed my MSc in construction law. If I'd have done that earlier, I'd been able to feed off a lot of people and perhaps get a better mark.
Well, I've started with the Wismut topic today, and I will continue with this topic, because actually I tried to get to the Wismut team when I was a 4th-year student of the law faculty. But that time I decided that I would write the memorandum on the last night before the deadline. And during that time I was organizing the conference in France. And well, we had 3 hours difference, I guess. So I saw that I will fill out all the forms for my conference, all the documents that organizers should do, and then I will start my memorandum. So in the end of the day, I just fell asleep next to my laptop, next to the draft memorandum, and I have never submitted it. And that's how I postponed my participation in the Vismut for 1 year. And 1 year I was just watching my friends who were just taking part in the Vismut and I was not. So basically the lesson from it is good time management. Just it's a key, remember about time management. And the second, never leave important stuff until the very last night. Just do it when it should be done.
From my side, at the early stages of my career, I nearly became a transactional lawyer. And I'm so happy that I didn't, because I would be so bored. But maybe transactional lawyers find their work exciting. I'm sure they do, but it's not for me. So I think don't be too fast to choose what is the right area of law for you, or what it is that you want to do as a job. Because I think the most important bit is that you really enjoy at least a greater part of what you have to do as your job, because we spend so much time doing it. And to be successful, you have to really commit and put a lot of effort in. And if it's something that you don't really enjoy, it becomes a lot more difficult and potentially miserable. So you want to avoid that.
Awesome. I have many regrets. However, we learn from them. Off the top of my head, the one I would say is that I perhaps should have been more active on my LinkedIn, because once I started using my LinkedIn more, I actually have gotten better opportunities and things have come my way just through LinkedIn. So I should have probably started updating it more earlier instead of later. Now, questions from the audience and attendees to the panelists. The first question is to you, Artem. This time you're not the last speaker. From Shanfung, it will be okay. The person asking the question is a penultimate year law student in the UK and also interested in international arbitration. How do you think by joining CIArb, would benefit their application for the TC, I know it's training contract, or VC? I don't know.
I assume VC is probably vacation scheme or something like that.
Yeah.
Look, I think just joining the Chartered Institute and putting that on your CV, to be honest, is not going to be much help. But the question is that we've discussed at the start of this conversation: how do you make yourself stand out from the crowd? And I think if you do join the Chartered Institute and you do go to the events and you do get to meet the people and you actively participate in the life and you learn the insights, greater insights into the world of arbitration, and you meet more people, potentially if they're also at the law firms where you're applying to, then all of these little bits add up to make it more advantageous for you to ultimately succeed. There's no guarantees, but you need to get every little advantage you can. And from my point of view, joining the Chartered Institute will help you, will create some opportunities for you to gain some of those advantages. There are other ways of gaining advantages as well, but you need to see what is best for you and how can you make yourself stand out from the crowd.
Okay, great. Veronika, the moot court you mentioned earlier, is it confined to a particular jurisdiction or is it free to any student from any particular jurisdiction? I believe it was the Vismut.
Yeah, I would start with the fact that there are a lot of moot courts in different fields of law. So just check them out if you're interested in public law. So maybe JASAP is your option here. If you're interested in the media law, then Price Moot Court might be an option. So just Google these moot courts. There are a lot of them. Speaking about Vismut, it's the commercial arbitration moot court. So if you're interested in this pathway, then just, check the website of the Vismut court. It happens every year, and there are like two divisions. The main one is in Vienna, and another one is in Hong Kong. So basically, you can choose the one which is closer to you. It's called Vis East. It's open to everyone. So normally in Vienna, they have 400 teams or even more from different jurisdictions. So what you need to do is just to register on the website and then later on to pay the fee. Normally the university does it, but there are the sponsorship opportunities and different organizations, they give you the sponsorship opportunity. Then you can find the coach. So normally the coach is a person who took part in the Wismut in any capacity, or it might be some person who did it, but who does not work for your uni or lives in your country, any other like virtual coach, which is very convenient right now with the development of the technology and with the fact that Wismut is going online this year for the second time in history. So now it's cheaper to take part in the Wismut because basically it's online and the fees are lower and you don't need to spend a lot of money on going to Vienna and staying there for a week. So yes, it's open to everyone. Please check the website. If you have any questions, feel free to write me on LinkedIn or to send your questions to CIArb and they can give you my contacts and we can discuss it in detail.
Okay, now there's this question, and this one I think I'll ask it to all panelists. Just comment, how do you bear the fact that you can't speak about your clients and cases publicly? Richard, you can say something, and maybe Artem, anyone else really.
Sometimes it's quite positive that you can't speak about your clients because they do things that you perhaps wouldn't advise them to do. So we'll probably leave it there. Obviously, you can talk about general principles with people and provide, you know, anecdotal response. You don't need to know whether party A is called such and such or whether party B is called something else.
Anyone else want anything to add?
I can probably add that when you're a young practitioner and when you only start working for a law firm, you're very excited about the big clients and big names, and you just want to share with your relatives and say, like, look at me, whom I'm working with. But then it just passes, you know, you just don't want to tell anyone the names and the details of the cases and anything like that. And in my case, for example, I believe my family, they just think from time to time that I work for some secret agency because I never tell what I'm doing at my work, and they cannot ask, I never answer any questions on that. So yeah, it's okay with the time.
Okay, yeah, I think that's well answered. Okay,
conversations with parents definitely don't, and even once you get to partner level, I still, every time I see my parents, they get to ask, so you can't tell us what you're doing for work? No, I can't. So okay, well, hopefully everything is fine. Yes. So yeah, those conversations never end.
Yeah, it's the same for me. My mom doesn't know what I do for a living up to now. I'm like, seriously. Anyway, this one I'll direct it to you, Artem. How can we connect with professionals in the field? And the training contract route is longer for international students. Shouldn't I grab the opportunities for international arbitration? The question is not too clear, but just comment based on the gist of what you've understood.
Okay, so the training contract route in England is the current route, the main route of getting into the profession of becoming a solicitor. And what it ensures is if you are able to join that route and then proceed through it, then there is already a structure in place that it becomes clear how your career will progress. But yes, obviously there are not enough training contracts, and so those interested in particular disciplines such as arbitration try to find alternative ways of starting their careers. And for example, working as a paralegal or getting some experience as an intern may be other opportunities of doing so. However, the problem with those is that you may get some additional experience, and that is always helpful to add to your CV. Those positions usually don't envision the way out and the way up. So a way to move on to the next stage of your career. And that is something that you would have to look out for yourself and try to figure out how to do that. And the problem that could arise there is that you could end up being stuck in a very junior position within an organization without a clear route about moving forward. So opportunities of trying to get some experience, I think, are very helpful, but always try not to overstay in those junior positions and think about more of a long-term career, in particular about the progression from one stage to another. Hopefully I've answered the question, or at least area to which the question related.
I think that will do for now. I'll move to the next question and I'll direct it at Nika, and then Richard, or you can add anything you want to. From one of the panelists on what do you think are the challenges in the field of ADR in the next 5 years?
Well, I guess that we can here speak about the ecological influence and about all of these numerous folders that we send for each arbitrators. Each of arbitrators, each of the parties, each participant of the hearings. So probably there is the way for us to think about making arbitration more ecologic friendly, let's say. And it will be the task for us for the next 5 years. Here the technology can help. Here all these new amendments to the arbitration rules can help, where the electronic format is available right now for the parties as the main one. So the ecological footprint is what we should consider during the next 5 years, I believe.
Mm-hmm.
Yeah, I'm probably leading into the ecological function. There's also diversity within arbitration. So there's a big push on that at the moment, especially within CIArb and other organizations where, you know, they are looking to champion young people and put them on panels, and more female representation on arbitration panels, because there has been a perception in the past that a lot of arbitration panels have been male, pale and stale. So hopefully, you know, moving forward, that will change. Obviously, we've got a rapidly expanding institute. You know, we've got sort of 4,000 plus members in Africa and 4,000 plus members in East Asia. So, you know, we are becoming a much more diverse organization.
Okay. I think I'll go to the next question. This is directly to Artem. Does Osborne Clark offer internships on an online basis to foreign students, and does it support cross-border practice?
A little bit of a lazy question, I would say. So my first answer is, this is a question that whether you're interested in Osborne Clark, you can have a look on the website about us or any other law firm to see exactly what is on offer. There'll be a lot of details there. There'll be a lot of information. So definitely look at that. In terms of online basis, I know that during the pandemic, I believe we still continued with our vacation schemes, and I think we had them in an online format, but I wasn't involved in that, so that may not be the case. But that's my belief, is that we continue to hold them in an online way, which is obviously not the best way of doing it, and hopefully we can return to holding them in person in due course. And in terms of cross-border practice as well, we are an international law firm. We have offices in most Western European jurisdictions, also in Singapore and China. We have a related company in India as well. So there are opportunities within those jurisdictions to join the firm at the junior level as well. But I think, to my mind, the question like this is, I appreciate it's good to ask questions on events, but really try to do your research in that and find the information that you can in the first instance.
Okay, I've seen the question on how one joins the young members group. I'll just say this: once you become an associate member of the young members group, so long as you're aged 40 and below, automatically you become a member of the young members group. I will just ask a quick question, and then when you answer the question, please give your parting shots as well, because we are 3 minutes away. No, actually 3 minutes I can manage. Just say something quickly. With a mass growing field, growing of the field arbitration. Okay, with arbitration growing, do you think the English language may pose as a threat to the growth, especially in countries where English is not the first language? Basically, just comment on language skills in arbitration, or basically ADR. And then after that, we'll do the parting shots. Just in any order.
Okay, so I mean, obviously arbitration is a consensual process. So, you know, if the parties to the dispute don't speak English, there's no requirement for the arbitration to be conducted in English. You know, it's for the parties to choose. So it shouldn't really constrain anything, in my opinion.
Yeah, I think it's perhaps a bit unfair to lay the blame at the feet of arbitration. I think English is a popular language for business, and perhaps that's why international contracts are concluded in English, but not always. And that's ultimately why English perhaps is used as ultimately the language for the dispute resolution. But there are many instances where English language is not used. I've been involved in Russian language arbitrations as well. I am being aware that in Asia there are plenty of arbitrations taking place in Chinese and other relevant Chinese language, and the other languages from Asia. Spanish is a popular language for Latin American disputes. We even at my previous firm, we had a Lusophone arbitration practice who practiced Portuguese language arbitration. So English is a popular language, but it doesn't have to be if it's not appropriate for the particular dispute.
Yeah, I agree to that. And I can say that the promotion of arbitration around the world brings us to the development of the local arbitral centers and arbitral institutions, which allows to hold the hearings in the languages which are more rare than English. And definitely it develops, and the number of these arbitrations, especially the smaller ones, it's growing. So I believe that we will not be limited to English language in future.
Okay, great. We've come to the end of this insightful and very interesting webinar, which I enjoyed moderating. And now I will have the panelists do their parting shots. And then after that, we'll be free to leave. My parting shots will start first, so that after that, I'll just count down to 5, we wave, and everyone goes home. Okay, goes back to bed, because most of you are at home. I'd like to say the highlight of this event: kindly join as a student member. You've had all the benefits of joining as a student member. Also plan to sit for the professional courses so that you get the experience, because as I said, luck is when opportunity meets preparation. Look out for opportunities to network, interact with people, and I wish you all the best. I think we'll interact on the social media streets and platforms. Even now as a student member, once you join the bigger family, with time you'll start knowing more and more people. So don't be so stressed when you hear some of these terms sound foreign. One day they'll be easy to you, because you will join as a student member and train. First of all, you need to train. I think I'm done. I look forward to meeting everyone one day in person maybe, and then we can remind ourselves of the day we had this webinar. In the same order that I introduced the panelists, I think Veronika, give your parting shot, and then Artem, no, Richard, then Artem. Then after that, we can wave bye-bye.
Yeah, thank you very much, Mercy, and thank you for everyone for attending today's seminar and for being very active and asking the questions. Stay that active, have your hope and work hard, and everything will pay off. Good luck with everything. Feel free to contact us, join CIArb, take part in the events. And we're looking forward to meet you in person. That's true. Thank you.
Well, thank you very much for attending. Hopefully you've learned a lot about the student benefits of the CIArb. Hopefully you'll go on to become members at some point in the future. And take obviously advantage of the offers that are on at the present time. Obviously the online modules for £25, they do represent very good value. So yeah, no, hope to see you all around, and good luck on your journey.
I'll join with the words of thanks from everyone else. I think the fact that you joined this webinar means you're already doing the right thing. So that's the starting point. you're on the right journey. There are many, the competition is fierce, but there are many opportunities out there. But you need to take advantage of the opportunities and put in the serious work to take advantage of them. No one else is going to do that for you. So you look out for the opportunities, be aware of them, and be open to them, and be prepared to do the hard work, and the rest will take care of itself. And I look forward to, in 5 years' time, when those who have been listening today will be the ones speaking on a similar webinar and passing on the wisdom to the next generation. Thanks all.
Okay. In 1, 2, 3, we are waving. Bye, guys. Have a lovely day and week and month. See you soon. Bye.